This week, in a federal courtroom, U.S. Marshals physically removed the sitting president of the place, United States, from the proceedings. Not because of protesters outside, not because of a security threat. Because the presiding judge determined that Donald Trump's conduct toward a witness had crossed a line that no court can tolerate. This moment was a profound collision between executive power and judicial independence, serving as a visceral reminder that the courtroom is a sanctuary of law, where the status of the defendant is secondary to the sanctity of the process. Before you dismiss this as media exaggeration or assume the worst based on a headline, I need you to look at what actually happened, not what pundits say. Happened, not what his lawyers claim happened, but what the court record shows with undeniable clarity. I've sat through hundreds of federal trials in my career, witnessing the raw tension of high-stakes litigation. And while I've seen defendants lose their composure and heard judges issue scathing warnings, what I've almost never seen is a judge ordering marshals to remove a defendant mid-proceeding. That action tells you something went fundamentally wrong. It is the ultimate sanction in a trial environment, because marshals don't escort you out for minor infractions, like eye-rolling or sighing too loudly. They remove you when your presence threatens the very integrity of the proceeding itself. To understand the gravity, we must dissect the sequence of events. The session began, like any other, with attorneys present, the jury in the box, and a witness taking the stand to provide testimony that reportedly contradicted Trump's public narrative. As the testimony progressed, audible disruptions began to emanate from the defense table, prompting a standard verbal warning regarding courtroom decorum. When the comments persisted, the judge called a sidebar, being direct and unequivocal. Control your client or face the consequences. Moments later, as the witness resumed, the court record indicates that Trump turned toward the witness and made a statement that multiple observers described as a direct attempt to influence or intimidate the individual while they were under oath. The judicial response was instantaneous. The judge halted the trial, stated for the record that the conduct constituted witness intimidation, and issued the order that will be analyzed in law schools for generations. Marshals, remove the defendant from my courtroom. Within 60 seconds, the courtroom was cleared of the disruption, and the trial continued in his absence, a move that highlights a persistent pattern of behavior rather than an isolated outburst. When we look at the timeline from the May 2024 hush money trial, where Judge Juan Merchan threatened removal for gag order violations, to the August 2023 January 6th case, where Judge Tanya Chutkan had to protect witnesses from harassment, we see a consistent trajectory that prosecutors identify as consciousness of guilt. In the world of federal prosecution, those who respect the legal process do not attack the people testifying. Those who fear the plaint, evidence do. Witness intimidation in a federal setting is a serious felony because it undermines the search for truth, and the law defines it as any conduct intended to influence, delay, or prevent testimony through fear or harassment. The authority to remove a president exists because justice depends on the equality of all individuals before the bench. If a defendant can disrupt the proceedings without consequence, the trial becomes nothing more than a theater of power. This judge did not invent a new power. She exercised an authority that has existed since the founding of the Republic to ensure that witnesses can speak without fear and that the jury can deliberate without interference. The immediate legal consequences for Trump are severe, ranging from being held in contempt and facing heavy fines to a possibility of being required to watch the rest of his trial via a video feed from a separate room. Furthermore, this incident acts as a bellwether for the entire American judiciary, sending a message that the rule of law remains a functional reality even in the face of the highest political pressure. I have prosecuted war criminals who showed more deference to the ritual of the law than what was exhibited this week. and that professional observation is not hyperbole, but a reflection of how far the boundaries were pushed. The question now is whether the system responds as designed, moving past the delays and appeals to reach a crestless verdict based on evidence rather than intimidation. This week, a federal judge proved that the phrase, "no one is above the law," still carries weight, showing that the process works when people have the courage to do their jobs. The trial continues. The next hearing is scheduled, and the jury will eventually deliberate on the facts, ensuring that the process remains an unstoppable force for accountability. Beyond the immediate removal, the legal community is now debating the long-term impact on executive privilege and the limits of the defendant's right to be present at their own trial when their behavior makes a fair trial impossible. Federal Rule of Criminal Procedure 43 specifically allows for a trial to continue without the defendant if they persist in disruptive conduct after being warned. And this week was a textbook application of that rule. The implications stretch into future cases, setting a precedent that no amount of political influence can shield a person from the disciplinary power of the court. As we move forward, the focus shifts to the jury's perception of this event. While they are instructed not to let the removal influence their verdict on the charges themselves, the psychological impact of seeing a defendant removed by force is undeniable. This reinforces the idea that the courtroom is a controlled environment where the judge's word is final. This event also underscores the vital role of the U.S. Marshals Service, whose duty is to protect the judicial process, not the political figures within it. In the coming days, we will likely see appeals filed by the defense team claiming a violation of the Sixth Amendment right to confront witnesses. But historical precedent suggests that these rights are not absolute and can be forfeited through misconduct. The system's resilience is being tested in real time. And so far, the pillars of the judiciary are holding firm against the storm of controversy. Every citizen should take note of this moment, for it defines the difference between a society ruled by men and a society ruled by laws, ensuring that the pursuit of truth remains the highest priority of our civilization.